Hello to everybody. Welcome. It's May 2nd, 2024. My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all today for coming. Today's program is Discrimination, Cultural Sensitivity, and Reasonable Accommodations, featuring Mark Gutthews as our presenter today. ECHO is a 51-year-old statewide nonprofit association established to support HOA boards and board members and our engaged homeowners. Our mission is to foster a better quality of life in community associations through advocacy, networking, and education. For today's event, we have a few housekeeping items. You'll find those on the screen. Please review those. They were sent to those of you who registered beforehand in your packet. Please take a moment and review the housekeeping items. Today we have a fairly medium-sized audience, actually, so we don't have as large as usual, but we will have an opportunity to answer your questions, and we will take them as we can. Mark feels pretty comfortable or is comfortable taking some questions during the presentation as well. At his prerogative, he'll answer those questions or not, depending upon the speed of the program. The Q&A session, it will be at the end of the seminar or the webinar, so you will have an opportunity to speak then. In addition to the live Q&A session, I will answer some of the questions via text in the Q&A feature during the presentation. So you can put your questions in the Q&A feature. Don't put them into the chat. We prefer to use the chat for personal conversation, direct messaging, and any technical glitches that you may have. For your questions, please use the thumbs up icon. You'll find it at the bottom of your screen, left bottom corner, and vote on your favorite questions. It can be your questions or it can be other people's questions. Please do that, and we'll use those to prioritize our questions during the Q&A session. Also, please keep your questions short and general in nature. We will have to pass over some of the questions if they're too complicated or too specific. And you might want to talk to experts who actually know your facility and you're familiar with what's going on in your community if you do have specific questions. Please use the chat feature to report technical issues and to communicate directly with other participants. We do not monitor the chat for conversations, for questions and answers. Now, let me direct your attention to the monitor where you'll find our disclaimer. None of what is said during this seminar shall be construed as specific legal advice or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. The information we provide during this webinar is educational in nature and should not be relied upon for your specific decision-making purposes. Thank you for that. This webinar and all our events are made possible by the generous support of our ECHO HOA professional service providers. Join me in thanking them today for today's program. Our program sponsor is Silver Creek Association Management. Our registration sponsor is Levy Erlinger and Company, LLC, CPAs. And today's gift card sponsor is CM Squared. Please stick around till the end of the day, end of the webinar, for a chance to win this $50 Amazon gift card. You must be present to win. Play Silver Creek Association Management video now, Connor, please. Thank you.
Hi, I'm Laura Abaza with Silver Creek Association Management. Our core mission at Silver Creek and the touchstone of everything we do is to manage communities with its people in mind. That means we don't just aim to check off standard management boxes, but to listen and cater to the unique individual needs of each and every member of a community. We believe in enhancing the livelihood of communities through our unparalleled dedication to customer service, our ability to offer professional expertise in all areas of HOA management, and our tireless drive to ensure that the communities we take care of are heard, happy, safe, and thriving. We aim to consistently go above and beyond the confines of typical HOA management duties. It's because we genuinely care about how your community functions. We understand that managing a community can be a demanding responsibility, but our team of experts understands how to get things done with efficiency and finesse. Please let us know how we can help you and your community. I hope you have a great education workshop today.
And thank you so much, Laura Ravazza from Silver Creek Association Management. Please support all of our sponsors and especially our professional members for making this program available today for little or no cost to you. In addition, we'd like to start our introduction here of our speaker. And his name is Mark Gutthews, Esquire, and he's the founder of Community Legal Advisors Incorporated, which represents more than 500 HOA communities. His firm provides assessment collection and general counsel services. For more than 20 years, Mark has provided general counsel and civil litigation services for the firm's community association clients. Mark also serves on the ECHO Board of Directors and is its vice president. Mark, take it away. Thank you.
Yes, I am, and privileged to be here. Today, we're going to talk about discrimination and cultural sensitivity and reasonable accommodations. And one of the questions that already came through the Q&A, which was the correct place, that said, hey, if we find discrimination, how do we solve the problem? And we're going to talk about that. We're going to talk about recognizing it, avoiding it, and what to do if you find it. So we're in good shape here. You're at the right place. So there we go. I'm going to talk a lot about how to handle these claims. As an attorney, it's my job as an attorney who represents homeowners associations. It's my job to try to minimize these things, to try to mitigate or make go away these claims. And so I don't want you to think, oh, well, Mark's never seen a discrimination claim that he thinks is bad. And the answer is no, that's not the case. I am saying that discrimination is not acceptable. It's not at any time or in any manner. And in teaching you to properly address a fair housing action, a discrimination action, it's to teach you how to make this stop. It's not to allow bigots to avoid responsibility for their wrongdoing. So I want to put that out there because as we talk about how to address the claim from the association's point of view, I have owners who have domestic abuse backgrounds and other kind of horrific circumstances, and they're saying, well, Mark, why are you teaching the association how to get out of this? And the answer is, well, really what I'm trying to do is teach the association the correct way to address the claim. So let's move on to the next with that out of the way. The first thing that I want to tell you is that bigots or people who act incorrectly believe that it's the obligation of the plaintiff, of the person who's complaining or the complainant, to prove that they've been discriminatory in some fashion. And I will tell you that the Constitution certainly establishes that we are innocent until proven guilty. I'm also going to tell you that the state of California incentivizes, pays the salaries of a government entity called the Department of Fair Housing to prosecute these actions based on these people's allegations. And so if there is wrongdoing, practically speaking, what happens is that the victim has the right to make a claim, which is as easy as booting up the website for the state of California's Fair Housing Department, log that claim, which is about getting the keyboard out and explaining how that wrongdoing occurred and how it affected you. And the state of California, if they believe that the issue has significance, will swoop in at no cost to the victim and start investigating and file a lawsuit, which, if the wrongdoer has acted intentionally, i.e., if they know that This is creating a havoc for the owner, and they just continue doing it. The defense of that action is out of pocket. What do I mean by that? You may carry insurance, homeowners insurance and that kind of stuff, but that insurance does not defend and indemnify you from an intentional act. And so we'll return to this when we're talking to the bigots, and talk about this, because it's very expensive to defend a claim. On average, my clients are paying between $50,000 and $70,000 for us to get them out of claims. There is not a phone number to report, or there may be, but just go on the website. So the point of the exercise is we have a governmental entity that's willing to prosecute. So you may prove yourself innocent $200,000 later, or you can stop the action. And this is sort of the gravamen of the answer to Michael's question. If we find discrimination, how do we solve it? And the answer is make very clear to the bigot that their actions will soon cost them a lot of money out of pocket in cash to defend. And they're fighting the state of California. So what does a potential claim look like? What does a potential claim for fair housing look like? And the answer is it can have a lot of different faces, but recognizing it has to do with passion. And we'll get into what all these different faces are. This is the overview, but let's think about it. A potential claim comes in when a person is truly emotionally or physically injured or damaged. And so what I tell my managers, what I trained my property association managers to do is to look for passion. What does that look like? It looks like a person who comes to a meeting and starts crying or is very angry, right? It looks like a 3 or 5 or 7 page handwritten letter, which ends with the words, and I think this happened because I'm a homosexual male, or I think this happened because I need you to address this immediately because I'm a cancer survivor, a protected class. I need you to address this immediately because he's 3 times my size. I need you to address this because as a Jewish woman, I don't feel safe in this primarily Muslim community. I need you, right? So what you're looking for is areas where people feel discriminated based on their race, color, creed, national origin. And we'll get into that in a minute. We're still in the overview. But the way you as a board recognize this before even the victim necessarily recognizes that they can go to the fair housing website and try and put in a claim is you're looking for passion. And I want to stop right there and say that most of us believe that the passion is distasteful and doesn't have a place at a corporate meeting of the homeowners association. And this was the case for many years, decades, hundreds of years, until about 5 years ago, when the state of California declared that we are housing providers. And as housing providers, we have an obligation to pay attention to these neighbor to neighbor style disputes. And so we'll get into it. So we need to recognize that there's a potential claim and we need to make an immediate response. What does that response look like? That response is inviting the person who is going through that rough time, who's making that complaint, who's making the allegation, invite them in for a hearing with the board of directors. That is what you're going to do. You're going to give them 15 minutes before the next board meeting. If you're not going to have the next board meeting for another 30 days, then you're going to put together a meeting in the next 4 or 5 days and give this person the opportunity to come in and vent and tell you what is going on. And we'll talk about the questions to ask and not to ask. But that is the immediate response. The immediate response is receive the letter, make the determination, call the attorney, and schedule a hearing. Okay. Mark, I'm a board member. I'm a volunteer. I donate some time to make sure that the property is properly maintained. I look at the accounting on a monthly basis and make sure no one's stealing anything. But the real question is, I don't feel certified or prepared or qualified to come up with the right decision in these claims. And the answer back to that is, don't worry so much about that. What you worry about is making sure what the Fair Housing Department, which is a department of our Fair Employment and Housing, it's the same group that we deal with when we're making complaints at work or we're receiving or representing employers who have claims against them. What that department is concerned about is that there was a process in place, that there was a process followed. They don't care so much whether the association correctly or incorrectly made a decision that somebody was guilty of being discriminatory, because that could really have its own legal issues. So let's don't worry so much about making a decision or making the correct decision. Worry about undertaking the process in a timely or immediate manner. So we're going to change the slides, but I'll take a look and see if we can. Boy, there's six comments in the chat. Let me see what we got there. Can a resident be sued for discrimination of an association employee? You bet. Can a resident be sued, or they can sue? What about, so great, neo-Nazis. Let's try and include those in our examples. I think you're going to see right now that all kinds of claims can be brought. So who can bring a claim under the Fair Housing Act? Who does this involve? Well, let's talk about it. The case is Revcock versus Cowpet Bay. This is a federal case, and it has to do with Cowpet Bay, which is the name of an association out in the American Virgin Islands. You've heard of the British Virgin Islands. The Americans have a few islands of themselves, and Cowpet Bay is a condominium association that is on one of these beautiful silky white sand beaches. And you would think that this paradise would lend itself to joy and happiness, but it didn't in this case. So who are the Revcocks, and why were they suing their association? What happened out there? Well, like California used to have a rule before we got our one pet rule, the associations have a right in the American Virgin Islands to preclude pets in their communities, and Cowpet Bay was one such community. And the Revcocks brought a couple of prescriptions, otherwise sometimes known as pets or dogs, but brought their prescriptions to the Cowpet Bay community. And of course, the Cowpet Bay community started talking, and they started talking on the community intranet. And there were a couple of people on the board who were active on that intranet. And so there was a lot of conversation about these prescriptions that looked like dogs. And at one point, the Revcocks got on that website and made the following pronouncement: we have provided the association with evidence that these dogs are emotional support animals. We have prescriptions for them. We have letters from the doctors identifying them as emotional support animals. We are allowed to have this under the Fair Housing Act, and we expect all further discussion about this to end. And it should have, but it didn't. The discussions continued, and the board president freely participated in the discussions. And, it wasn't very favorable. In fact, there was really on the internet, this community internet, there was discussions about blackballing and being rude to the Revcox and that kind of stuff. And so here there was the scenario. Now here's kind of how passionate the federal government is about preserving the claim. In Revcox, the Revcox actually died. They passed away, but not before they sued the association under fair housing, and that the federal government stepped in and started prosecuting. And the Cowpet Bay defendants said, hey, the Revcox are dead, and so this action should end. And the federal government on appeal, the 9th district or 10th, well, whatever the district is, first or second district out on the East Coast, said, no, these acts survive death. The point of these acts is to punish people to stop the activity from continuing to happen or happening at all against anybody. That's the point of the punishment. It's not to compensate the plaintiff. And so who did the Revcox sue? Well, they sued fellow owners who were on that website. They and talking about the dog and how they were going to blackball the Revcox. And they sued the tenants, the other people who were on that community website. They sued guests who made comments when they passed them in the hallway. They sued the employees of the association. And who did all of this on their behalf? Well, the Department of Fair Housing. I include vendor on the slides because I want you to know that if your association has a beautiful female vendor who comes in to provide landscaping updates and your board is sexually harassing of that person, the Department of Fair Housing, if a claim is made, can bring an action against your association on behalf of vendors who have a right to approach your community without being harassed. So this should begin to give you a flavor of what this presentation's about. And that flavor shouldn't be, the sky is falling. The flavor should be, oh, we do have a responsibility in this matter. And when we overhear untoward comments, we probably should move to do something about it. We should move to educate the people involved. So let's continue. Let's go to the next slide, and I'll just take a look at what's been said so far. So can a resident be sued for discrimination? Yes. If an association employee puts everybody on notice, hey, I'm being harassed here, and the association does nothing about it. I call this scenario the manager in a box. The manager is down there on the ground floor, and there's an elevator bank on both sides of their office. And I have an association before we did a training like this, had an association where the people would come down the elevator, flip off the manager, and call her all manner of names because they didn't agree with her enforcement of the parking regulations, and just duly moved on. And their thought process when we brought them in for hearings is, well, she's enforcing the parking rules and she's an employee, so screw her. And the answer is, do you realize that this is a really unfavorable working environment for this person, California Fair Employment and Housing, and that we're all subject to getting sued by your actions, which are intentional and we're going to cross complain against you if this continues. Okay. So yes, the manager in a box, the employee in a glass house has legal rights. What about neo-Nazis? Okay. Let's take a look as we go through the examples. We'll try and address that. So what discrimination laws apply to homeowners association? Excuse me. Well, I was just looking at a chat. I believe discrimination exists when homeowners report to management issues of concern, maintenance, repairs, and their concerns get ignored because management gives priority to the board's own personal repairs and concerns. Well, that's not the kind of protected discrimination that we're talking about. And we'll talk to you about the classes of people, but the owners versus the board members isn't a protected class. So fair housing isn't going to get involved in that scenario. So let's talk about who does the suing and how do they do it. Well, the federal government has a couple of legal procedures or things that they rely on. One is the Americans with Disabilities Act. And so we know that under the Americans with Disability Act, people who have disabilities have rights to access public and to some extent private places within the community. And it's the obligation of the commercial association in the situation of the American with Disabilities Act, public accommodations like commercial associations, to provide for and allow ingress and egress by folks in wheelchairs and otherwise handicapped. Then the Federal Fair Housing Act. Now, I will tell you that it was the Federal Fair Housing Act that prosecuted the prior case that we talked about, right? And the federal government, if you make a claim in the state of California through the federal government's website, the federal government will just shoot you straight over to the state of California. They will forward your complaint to the state of California. So although the RevCoc action was taken by the federal government in California, it would be done by the state government. So the states pursue under the Fair Housing Act. They pursue under the Unruh Act. The Unruh Act basically says that we can't discriminate on a basis of race, color, creed, national origin. We'll get to that. In the most famous prosecution that we have in the state of California is the O'Connor versus Village Green case. And basically what happened was in O'Connor versus Village Green, the Village Green Community Association made the determination that they were going to have adult pools versus children's pools. You remember that, those days? Or, where I used to go, where we used to recreate at a mobile home park out in Palm Springs, they had adult hours and children's hours so that we weren't swimming with the adults. So that went by the wayside. The court came back and said, no, we cannot allow disparate use of the facilities or disparate facilities based on age. So there's fair housing at work. And then there's local building codes that handle discrimination, which is to say that when commercial tenants make improvements, when they move into a site, the federal or the state government can require them as part of the building improvements to spend 5% of that to improve access, ingress, egress as part of their permitting process. So that's how the local building codes get involved. So we'll have you move to the next slide, and we'll just take a glance at where we are on the thing. Oh, I'm going to give you examples there, anonymous. Examples of harassment, gender and ethnicity, and that kind of stuff. And then let's see what we have over in the chat. Can an HOA be gun-free? Oh, heavens, I don't think so. Yep, Second Amendment, got it. So there, I think we're kind of caught up. Oh, what if you can't ID the perpetrator or they're posting anonymously online or in the common areas? We're going to talk about that. And you guys are really fascinated about your female board members. So we'll have to take a look at that. So just sort of uh, responding to the Q&A generally, board members are humans too, and they're members of the association. So they have the same legal rights that other members of the association have. So if owners come in and attack the board on a regular or routine basis, the board has fair housing protections against owners, and owners have fair housing protections against board members who are not acting in their position as board members. So let's say that I was on a board and I came to you and I said, hey, according to our bylaws, and I'm the architectural committee, and we're supposed to reach out to you because your house is a beautiful what is that color? Eggplant. That's not purple, of course, it's eggplant. And that's not consistent with the governing documents. My discussion with you would be protected because I'm acting as a board member about an item of business. Now, let's say instead that I just came over to your house and said, you know, I don't like the color of your house, and I punch you in the face. That would not be protected, right? And so in between, the details shall fall. So maybe this will end the fascination with board members and we can sort of get back to discrimination. The answer, if you go back 2 or 3 slides, would you go back 2 or 3 slides to where it says who can sue? There we go. No, that's it, Revcock. Owners can sue. Owners can sue tenants. Tenants can sue. Tenants can sue owners. Owners can sue guests, and tenants can sue guests. Your employees can sue the owners and tenants who discriminate against them. Everybody can sue everybody under the Fair Housing Act if there's housing discrimination. So there, hopefully that brings an end to that. Let's move on to a couple more slides. Okay. So what about Americans with Disabilities Act? How does that apply to our community associations? And the answer is when we get somebody who comes into the association and they say, hey, you've got to do this because it's Americans with Disabilities Act, the answer is maybe, but probably not. The Americans with Disability Act pertains to commercial properties. It's accessibility to commercial properties and government sites. It's not access to residential properties. Where the ADA drops off, where there isn't protections for handicapped or injured or damaged people to get full enjoyment and use of the property, we're really looking over at the Fair Housing Act, not the ADA, but the FHA. So what about when an owner calls and they said, hey, you took away the pool lift and I can't, I'm in a wheelchair and I can't use the pool now. Or what about, hey, because I'm now in a wheelchair, I need curb cuts, or I need you to remove this set of stairs, and I need you to allow for better access and ingress and egress to the property. Well, we're going to talk about those examples a little more in a minute, but the answer is that's not ADA, it's fair housing. And yes, we have an obligation to stop, look, and listen. We have the opportunity to do what? I hope by now you understand we have an obligation to meet with that person and have a hearing and listen to how they will, what they need in order to gain full use and enjoyment of the property, including access to their units. So the distinction between American with Disabilities Act and Fair Housing is simply that ADA applies to commercial, where fair housing and FEHA apply to residential. Okay, next slide. Is a rented condo a commercial property? No. It's a residential property. Okay. So when is a party required to address a third party's discrimination? So as I shared with you when we touched in, when we started, we didn't need to used to worry about these allegations, these claims, these things, because we always said all we do is maintain, repair, and replace the property. That's our job under the CCNRs, and we really don't have authority over the owners to do anything. And there was kind of a really horrific case, and this is kind of one of those situations where, you know, evil facts makes law, and what are we going to do about it, right? Well, that evil fact was Reeves versus Carrollsburg Condominiums Association. And in that situation, in that case, what we had was the following fact pattern. Mrs. Reeves was a government employee. She was a woman of color, and she actually went to work every day by walking past a quintessential 60-year-old male bigot, white dude who said such loving comments on, did he say to her, hey, have a great day at work, I hope everything goes great? Nope. What he said was, you're a fucking blah blah, and I can't wait to kill you when you come home. Or he called her other names and made other threats. And this happened day after day. And Mrs. Reeves sued the association and the neighbor and said, hey, I can't live here, and I can't live near this person. The police have been there on a variety of occasions and have warned this person, and he says he's just making jokes, but I don't feel safe. And I can't sell my house because I would have to disclose to everybody that this bigot lives here. And so, association, you should buy the house. And the association said, yeah, that's not our business. Our business is taking care of the property. This relationship with your neighbor who calls you names and that kind of stuff, that's your problem. It's not ours. And it sounds like a police issue. And frankly, the police should be more involved. And that lawsuit went on for about 5 years and about $250,000 on the association defending itself, and the state of California continuing to sue the association. And finally, they deadlocked. And the realization by the Fair Housing Department was, we really don't have a law that we can make the association do anything. And so the feds got the laws passed. And here is the law, 24 Code of Federal Regulations 100.7. A person, who's a person? A person is a person. But you know who else is a person? A corporation. A corporation is a legal person. So the association and the individuals, and any individual, is directly liable for failing to take prompt action to correct and end a discriminatory housing practice. So there we go. That's how they suck the association in. It's a discriminatory housing practice by a third party where the person, that's the association or the board, knew or should have known about the discriminatory conduct and had the power to correct it. So under 24 CFR 100.7, when one of our owners tells the board of directors, hey, I've got a problem, and that problem arises out of race, color, creed, national origin, sex. So, you know, if you have a female who says, I feel, you know, attacked because I am female, and this is a male who's attacking me, any of these parties have a right to make a legal action. Well, have a right to make a report to the state of California under fair housing, have a right to make the report to the association, and seek the association's help. And it's the association's obligation as a housing provider to do something, right? If they knew or should have known and had the power to correct it. Well, when this law came through, all of the attorneys, people like me, got together and went back to the housing, Fair Employment and Housing, and said, well, wait a minute. Our CC&Rs don't allow us to throw out bad people. Our CC&Rs don't allow us to throw anybody out, their owners or their tenants, but that contracts directly with that owner. They don't allow us to find somebody who behaves improperly or tells bad jokes or whatever it is. We don't have, all we can do is bring people in for hearings and talk to them. And the Fair Housing said, yeah, that's enough. That's what we want to do. Now, this is good news and bad news. The good news is, from an association point of view, as I've already shared with you, I want you to bring them in for an immediate hearing. If they claim that there's a problem, bring them in for a hearing and hear them. Then the board can make a determination with legal counsel what they want to do next. But the way you run afoul of the Fair Housing Department is not taking action. Take a wrong action or a poor action, and that's much harder for them to prosecute. But if the association takes no action, well, that's how you're going to end up getting sued by the Department of Fair Housing. So, how do we avoid these actions? We respond immediately. We listen for passion, right? That 5-6 page letter, and we have an immediate hearing to learn about it, and we make a determination what we're going to do. So Mark, Reeves sounds like a terrible situation, because obviously nobody should have to live in that scenario. But people are people, and sometimes it's a community ride, morass situation. Does that mean that the association has to get involved every time? And the answer is, yeah, kinda. And it goes like this. You got to hold the hearing. So in Lawrence versus Courtyards, Lawrence was the name of the owner, and Courtyards was the association. And essentially, the Lawrences were African-American couple who lived in a community, this is the court's description, a diverse community of Eastern Indian, African-American, Hispanic, and Caucasian descent. That was the description. So a very diverse, very integrated neighborhood. And the Lawrences sued, but first put the association on notice, hey, these people are calling us the N-word. And we have a right to come and leave the house without being called the N-word. And of course, everybody responded, and they came in and they held a hearing, and then they started inviting the neighbors in who were calling the Lawrences the N-word. And what came out of the hearings, and this is the first time you're hearing me refer to the other side of that hearing, which is you have the hearing with the complainant, and then you have the ability, if you think there's validity or liability or purposes in doing it, of bringing out the people that I've been referring to as the bigots, the people who are on the other side, the people who are making the statements, right? And they brought in these people, and essentially the people said, sure, we call them the N-word. They call us fags. We're spics. I'm trying to think of other horrific racist names. And the answer is that's how everybody refers to each other in this neighborhood. That's the neighborhood. And the association didn't know what to do and basically sent out a letter and said, stop calling each other racist names. There's nothing we can do here. And so the Lawrences sued, and the Department of Fair Housing took up the case. And the Department of Fair Housing went through their investigatory process and sued the association. And the association came back and said, what? What did the association say? To successfully defend the claim. And they did successfully defend the claim. The association said, we immediately held a hearing when the Lawrences first complained. We brought them in and we learned about the facts. We hired an attorney. We held a hearing for all of the other neighbors that the Lawrences identified as saying wrongful things. In the hearings, we learned that the Lawrences were equally guilty, that this is how the folks spoke to each other, that this is a very integrated community. This isn't, a bunch of white people calling the Lawrences the N-word. This is how this neighborhood operates. And the court came back and said, okay, you did it. You successfully did what you need to do. You held hearings, you brought it to the attention of everybody. You can't govern how people behave. So now you begin to see the framework of how community association attorneys are counseling their boards of directors to act. Okay, so we're seeing some more examples, right? We've seen black on white, white on black. We've seen African American and Hispanic and Caucasian. So we're seeing that this is occurring in all different contexts, and we're beginning to smell what the courts are worried about. Again, what you're looking for is passion. And I'll give you a different example just to give you a different look at fair housing. We received, remember a few years back, maybe 10 years back now, there was a 100-year storm in San Diego, and we handled a couple of San Diego high rises. And in the high rise, we had an owner write the 7-page letter, and at the end say, I'm concerned about mold and water intrusion because I'm a cancer survivor, protected class. All right. So we set up a meeting with her immediately. Next day after the storm, we came because she had written the letter the day of the storm. And so the next day we held a hearing with her. We heard her out. We offered 2 different solutions. The association would go in with a remediation company and make sure that there was no water and dry it out if there was. And we would get a window opinion from they call window experts fenestration experts. Sounds like fence, but it's fenestration experts. So we hired the manufacturer of the window to say, did this window fail or did it behave the way it's supposed to behave in 100-mile-an-hour winds? And he came back, the manufacturer came back and said, no, the window performed the way it was. And the board kind of looked at that situation and went, all right. So we hired an independent. We call it a second opinion from somebody who didn't have a tie to the company. And that person informed us the same thing. They said, no, windows aren't watertight. They're water resistant. And if you get enough wind, it's going to blow water into the drain holes and up into the windows. So you are going to get water inside. It's not a construction defect. But you are going to get water inside. And so we came back to her and said, look, we're willing to do these things. And she ghosted us. She disappeared. And so we wrote letters to her on a quarterly basis. I called these stand ready letters, and I just simply put them on my calendar. Every quarter I sent her a letter that said, hey, we stand ready to come in and address the water intrusion issue if you would like it addressed. Her position was she didn't want people in her unit because she was afraid it was going to blow the mold around and damage all of her furniture and that kind of stuff. Okay, time went by, 6 months, a year later, we get a call from the Department of Fair Housing. You've been discriminating against this owner. They contacted you with this problem. You didn't respond. And, we need to come down and have a meeting with you and go through a questionnaire. And so we did. And so we went through the process and gave all of the information to the Department of Fair Housing. And the Department of Fair Housing went all the way through their process, including telling the association, well, this matter can go away for $10,000. And the association said, no, we're not We're not paying anything. We did the right thing. And then the Department of Fair Housing dismissed the action. Okay, so we had gone all the way through the legal, we didn't go through the legal process of trial, but we'd gone through all the investigation. And we were about $40,000 in legal fees by that time, having coached the manager how to answer, having produced all the documentation, having gone through a discovery process with the Department of Fair Housing. Again, no insurance. The insurance said, oh no, the allegations of the Department of Fair Housing are that are intentional act, and discrimination is an intentional act. So there's no insurance. And so the association had come out of pocket to defend this claim. So my story is this, that in the end, we sat down with the Department of Fair Housing, put them on the speakerphone in the middle of the house, in the middle of the office with my 6 attorneys, and we all peppered the department with questions. And we said, really, what else could we have done? What was the proper way to handle this owner? And the Department of Fair Housing came back and said, you did exactly what you needed to do. You held an immediate hearing. Once you heard the problem, you tried expertly to address the problem, and you reminded the owner that you were still available to address the problem. And so that's the model that I want to impose or impress upon you guys when this happens. So it can look like a variety of different things, but we look for passion. And if we have passion, then we go ahead and hold a hearing. Okay, I'm going to go to the next slide and I'll look at some of these questions that are on site. We'll start with the chat. Well, parking spot question. That's great. We'll get there. Let's say an employee has been discriminated against. Okay, so make it a landscaper. Is the complaint against the employer, the management or association, or the HOA? So the claim is going to be against the, let's say it's the landscaper in my example, or the property manager. Let's say that either one of these people. They're probably going to sue their employer, but they're also going to sue the HOA. And if they can, they're going to sue the individual who is doing the discriminatory practice. So it's just a matter of identifying who said that to you, who allowed it to occur, the manager or the management company, the HOA, my workplace. So who did it and who allowed it to occur? That's who the lawsuit. An owner asked for, was my opinion, a parking spot. Okay, so we're going to talk about a parking spot closer to the elevator if she is disabled. That's certainly an appropriate request. The HOA board was so negative, she canceled her request. I felt the board should be warned that this kind of behavior cannot continue, and maybe a speaker should be brought in to explain reasonable, and I suppose the next word is maybe accommodations of the board and also HOA members. That's correct. This is a real issue, and I'm glad, because it's exactly what we're talking about today. So let's go over to the Q&A. Other examples of harassment. Well, I hope we've seen that it is anything identified in the Fair Housing Act. So responsibility, what is the association's responsible for member-led chat groups? The answer is, if it's the association's websites, which I highly suggest that you don't have a situation where owners are posting on an association website, then you should take it down, right? So that's part of the liability of the Revcock Bay Association, is that was their intranet. Now, sometimes in associations, you have people who just friendly start a Facebook group, the Happy Acres Facebook group. Much more difficult to control that, right? The HOA can send a letter. We just had a situation where a couple of young people got active in a shower in the HOA, and the HOA, the owners took pictures of it as they were walking past the shower and posted it. And my concern, of course, is that the female participant seemed young. And so we contacted the police, and the police said, yes, indeed, that person is underage. Well, that's crime, right? So we can't have it on a website. So if it was the association's website, we'd take it off. What we did was send a letter to the person, or we actually put on that Facebook site, hey, suggest you take this down. Dave, you just popped in. So are we taking an intermission or a break, or are we continuing forward?
Continuing on forward. Go ahead.
All right, great. Is age a protected class? Yes, age is a protected class. So that's the example that I was giving you earlier about the pool times where we were saying, hey, you can have adult hours or children's hours or something like that. This is a great article. Great. In the Lawrence case, who paid the legal fees? You did. Remember, the people suing was the state of California. So that's your tax dollars. And then they're suing your association. So that's your assessments, which are paying for those legal fees. So Lawrence was a walkaway. That was essentially a negotiated, or it was not. It was a judgment in favor of the association, that there was nothing the association could do. The association was a prevailing party, but there were very little fees awarded because the courts, as a rule, don't want to discourage people making these sorts of claims. Okay, that's a fact pattern I don't even want to go to. So I'm happy to talk to you anonymous maybe later. So we talked about postings and that kind of stuff. So what do we do? We're going to hold this hearing. And the question is, what is the board supposed to say? So I have the most recent one I did. I had a person who lives in the community, and the person makes a claim against the association that the board president, who is actually running for office, woman, has made inappropriate statements to him in an elevator. Says the inappropriate statements are that she doesn't like my kind in the community, and so that we don't belong there, and that she's going to do her best to get people like me out of the community. So we immediately held a hearing. All right, we bring this person in and we say, well, what do you think they meant by this, right? And the person says, look, I don't know if it's because I am Black. I don't know if it's because I'm male. I don't know if it's because I'm gay. But I think any of these things might be the reason that she was talking. I felt that she was talking about gay. When she talked about me and my friends, I felt like she was talking about the fact that I'm gay. So, okay. So what are your needs? What do you need in order to have full use and enjoyment of your home without being discriminated against? And that person's first statement was a little impossible. We need the board president out of here. Okay. That's one possibility which the board can explore. Well, what else would you like to do? What else are some things we can do? Well, I want to be heard. And this is an important and reoccurring theme. And I think the reason that these hearings are successful, and they are successful, because a lot of times, just when people can voice their victimhood, right? And I don't mean that in a negative way against that person, but when a person can voice what happened and everybody around looks around and says, holy smoke, that really was an inappropriate thing to do. That's awful. And we're sorry. And, we will do what we can to help resolve it, right? And that's kind of anywhere in the spectrum, right? If somebody walks into the association and they're towing a can of oxygen, what are we going to do? And they ask for a front row parking space. What are we going to do? We're going to look at them and say, what's going on? You can't say, what is your disability? It's pretty obvious they're towing a can of oxygen. Or can you prove it? We might ask for proof in form of a doctor's note or documentation, we call that. We say, hey, before we, give you the front row parking space, is there something that we can do in terms of documentation? But if their disability is evident, they're towing an oxygen tank, they're rolling in a wheelchair, then we're not going to really go there. That's the law. The law says if it's evident, then we don't ask. If it's not evident, then we can get into larger questions of documentation. But we can say, what would you like the board to do? What would you like the community to do? I want you to fire that manager, my manager. This is ridiculous. I shouldn't be groped when I walk into the copy room, right? And then the association as an employer or as an administrator can say, great, thank you. You've been heard. And the association can make a determination what they want to do. Now, in the case of my board president, what we did was we held a hearing without the board president present, right? And then we held a separate hearing with the board president. And the board president says, I didn't say anything like that. And the board president said, you know what? We have cameras in the elevators. And that would be evident in the camera on the elevator. And the manager said, yep, we do have that. And you can watch the video and you can see that something is said, but there's no audio and it's unclear what was said. And the manager wasn't offering or the board president wasn't offering speculation on what was said in the elevator. Okay. So we know we're going to hold that immediate hearing and we know we're going to talk to that person about what happened. And if that person can identify the person who is making the statement, the person that I just colloquially identified as bigot, right? Or in my earlier examples, then we have the opportunity to bring that person in. And we're going to have a conversation with that other person. Well, this is the same conversation that I had roughly with that board president, which was, hey, did you make these statements? And the answer, shockingly, is they absolutely deny it. They say something akin to, I didn't say it, and you can't prove I said it. And I say, that's great. That's great. And here's why. Because we're here on behalf of the association today, which is the entity that's going to get sued. And if the association gets sued, they're negligent if they don't hold these hearings, which we just held. And if we don't take action to stop the thing, which we've just done. But if the behavior continues, which it won't, because obviously it never occurred in the first place, we're going to cross complain against you and you're going to defend the lawsuit out of your own pocket because we've taken action as the corporation to stop the behavior. And believe it or not, the combination of having the hearing immediately where the person is heard and the combination and that combined with the discussion with the person when it's appropriate to talk to a person who's acting in an appropriate manner, when brought to the attention that they're going to be spending tens to hundreds of thousands of dollars defending a lawsuit, believe it or not, the behavior tends to stop. So even if we can't prove it, we sort of resolve or handle what the Department of Fair Housing wanted us to do, which was to stop the behavior. Let's do another slide and I'll look through and I'll try and remember another example. The parking space example, that's a great example. So let me see if I can kind of scroll through. How do you address the fact that management gives, oh goodness. How do I address the fact that management gives priority to a board's urban repair of the homeowners, even though the homeowners reports were reported first? Okay, that has nothing to do with fair housing or discrimination based on race, color, creed, national origin. So my guess is that if it's a fact that management gives priorities to boards' homes, it's because the board volunteers time to try and make things happen for the community and tries to fix that first, or at least are there. Get involved in your community, volunteer your time. That probably help you get what you want to accomplish. from a pedestrian's perspective, Mark appears to be an expert's expert. Kudos. Oh, thank you. Thank you for the compliment. All right, so let's get over to Q&A and see if there's answers there. Okay, I don't see any new questions, so let's talk about Gittleman. So this is always the parking space issue, and the parking space issue is not unique. It's probably 50 to 70% of case law across the country as it pertains to fair housing. And it has everything to do with the hundreds of models that people handle parking. And it goes like this. In Gittleman, versus Woodhaven, the Woodhaven community had open parking, sort of. No, this isn't that case. That's funny. I'll give you a different case, a different example after this. In Gittleman, what Gittleman stands for is, where is the line? Where does the court expect the association to pay for things versus not pay for things? So under California law, and which is consistent with federal government law, if I am a handicapped individual, if I'm a roller, let's say I live in a wheelchair and I need to get across the common area, I have the legal right to change. The board has no option but to allow me to change stairs into ramps and things like that in order to allow me full use and enjoyment of my unit and perhaps the common area as well. And so the question becomes, how far does the board need to go in paying for these or reversing these improvements, right? Under California law, the statute says that the owner may, at their own expense, make the changes to their units and the common areas, so long as it doesn't structurally damage the buildings, okay? California law also says, by the way, that the owner has to put it back afterwards, but federal law says otherwise. From a board point of view, and what I'm going to tell you is that when an association addresses these issues, they have an ability to rise above the minimum requirements. And the example I'll give you, I represent a co-op, and the co-op is actually kind of just right down by the La Costa Resort. For any of you who come down to La Costa and play golf. And it's a terrible old 1960 or 58 building. And it's an interesting building because you step down 2 steps into a courtyard, and then you step up 2 steps on the other side of the courtyard into the front of the building. There is an elevator at the other end of the building that goes down to the parking areas. So in theory, a person could access an ingress through the parking lot if they were wheelchair bound. But this person said, well, the majority of what I like to do and my use and enjoyment of my home is accessing the La Costa Club. And I like to go over there and I like to play cards with my friends, and I like to utilize the 6 or 7 restaurants there, and I love the common areas, and it's just truly the amenity of my home. And so what I'd like to do is build a ramp across the common area in order to get full use and enjoyment of my home, the access and ingress and egress of the facilities. And the board looked at that and said, holy smokes, that's not just a ramp. That's a major architectural feature of the front of our buildings, because the ramp was from the top of the stairs across the courtyard to the bottom of to the top of the stairs on the other side. And the board kind of looked at that and said, hey, what do you plan on spending on that? And the owner came back and said, it's substantial. It's going to be a $15,000 wooden bridge improvement. And the board kind of waffled for a while and came back and said, what if we put in a ramp and you donated your $15,000 towards that ramp? And the owner said, hey, as long as I'm able to access this is what I want. And that's what the board did. The board said, look, we're all 75 years old, and we're all getting older, and sooner or later, a lot of us could be in wheelchairs. Why don't we make this more wheelchair accessible by putting in a ramp, a beautiful ramp, instead of a skateboard ramp? My point is, boards can utilize this information, and they don't always have to assume that the person's just trying to get one over them. They can actually look at it as an opportunity for somebody in process ahead of them and implement changes that help the whole community age in place. One of the common things is always parking, and Gittleman is that example. So I gave you the purpose of Gittleman, which talks about who pays for what. And in the example that I gave you about the co-op, I'm talking about who's paying for what. So even though the association wasn't required to pay, they maybe chose to as a capital improvement. In Gittleman, everybody had assigned parking spaces, and Gittleman came to meaning that they were deeded to the properties. So you parked wherever you were deeded. It was assigned parking. And the Gittleman came in and said, look, I need front row because I have a lung issue and I'm pulling an oxygen tank. And the association said, there's nothing we can do about this. These are all assigned spaces. We don't have a right to take somebody's space. Goodbye. And Gittleman sued. And Gittleman sued and said, hey, under the CCNRs, there's a provision for people to trade parking spaces, people to sell or convey parking spaces. And that's done under the authority of or with permission of the board of directors. And we believe that the association didn't do everything that they could do to help us accomplish that trade. And the court came in and ruled in favor of Gittleman and said, you know what? The failure of the association to invite the owners of the nearer parking spaces into a hearing and give them the opportunity to trade spaces with Gittleman to make those introductions was a violation of the Fair Housing Act. The court was careful to discuss. They said, look, it's not the association's obligation to undertake the cost to make the improvements, to make the changes, but it is the association's obligation to do everything administratively possible to facilitate the owner's full use and enjoyment of the property. So that's the line. The line is you got to do everything you can dream of possibly doing under the CCNRs administratively, because you don't actually have to come out of pocket to do it. Even though that administration costs money, the courts don't care about that. The legislature doesn't care about the cost of administration, only the cost of improvements. That's where that line is. Okay. So I talked to you about another parking space situation because there's so much fun. There's another kind of famous case out there, and it doesn't matter what the name of it is, but the situation was that the association, a senior association, had open parking, and they had a system whereby the people who signed up first got the closest parking space. And so it sort of grandfathered over time that the people who were there the longest were able to utilize the most near parking spaces. It was kind of a reward to the people who lived in the community the longest period of time. Then an owner came in and said, hey, I need that front row space because I have lung cancer or whatever it was. I think he had cerebral palsy. And the group said, no, we're all old. You got to wait your turn for that space. And the court rained on that association. Said, absolutely not. We cannot allow you to allow these owners to discriminate against this person. You have open parking. The association has control of the parking. You're making a decision to give that parking based on a seniority process, but the law says that you have to give it based on a need process. And so that is what happens in those communities. So 4760, California 4760 says that it's the owner's obligation to pay for those improvements and that kind of stuff. So We're going to go to the next slide. I know that I'm a little over time, but this is sort of the summary slide. And we're kind of handling questions as we go. So putting it all together, what are we looking for? Well, we're looking for an immediate dialogue. This is Pell Place, is the situation where I was talking about the water intrusion. And the Department of Fair Housing is really a one-trick pony this way. If you fail to hold that immediate hearing, you could get sued. So you hold the immediate hearing, you open a dialogue, you listen, you document what was requested and how you're going to respond. You communicate genuine compassion. I can't tell you how important this is. When I work with boards that sit there and say, Jesus, this is terrible, I'm sorry, that tends to deflate the situation. When you have a board that just sits there silently and blankly stares at the person making the complaint, I think as men, we often think that when women cry, they're being manipulative, you know. That is the situation that those associations then go on to get sued. So we need to conjure genuine compassion, even if we don't necessarily have it in our heart. And feel free to be creative in terms of your solutions. Sometimes I have owners who say, well, I want the front row parking space because I need to park my car, and that's the only way I can get handicap access. And I say, well, that's fine, but we'll trade you for your other parking space for the pendency of your illness because we still need that parking. And the person goes, oh, well, wait a minute. I was really just hoping for an extra space for my extra car. So you could be creative and sit and talk about those things. So that's putting it all together. Next slide. What can you say to other people? And this is kind of the attorney telling you, be careful. When somebody comes in and makes a fair housing claim, that's an executive session issue. We don't talk about it outside. But when we're making our reasonable accommodations, that can be more public. What do I mean by that? If Dave Saponi comes into me and says, hey, Mark, I'm a veteran and I have a broken back and I want to have a jacuzzi on the deck. And I say, hey, Dave, the association doesn't allow jacuzzis on decks, but you're a veteran and you have a note. I'm willing to do that. I say, but we need this. If you put a jacuzzi on your deck, other people are going to ask for the ability to put a jacuzzi on the deck, and I'm going to tell them no. And they're going to sue me for being discriminatory for allowing you to have it and me not allowing anybody else to have it. So I need your permission, if we do this reasonable accommodation, that we can explain to people why we gave you that jacuzzi on the deck. Geraci stands for the proposition that if we talk about a fair housing issue outside of a courtroom, which is considered a public venue, then we're liable for that information getting out. Okay, so we can't just tell everybody everything. We can tell everybody what happens in court, but we can't tell everybody what happens in a fair housing hearing. So that should be about the end of the slide. Connor, do you want to go to questions or more questions, or do you want me just to go to questions, or did we kind of run out of time?
No, we're good. Let's go ahead and I'll we have a couple questions we can get to here. I know you've been answering as we go, so
Ryan,
let's go ahead and upvote. Everybody should have upvote your favorite questions. Remember, there's a little thumb, or get it over here somewhere so you can see it. There's a little thumb in the corner, left corner. Upvote on your favorite question, and then Mark will take maybe 2 or 3. Mark, I think that's where we're good.
Sure.
And then if I'll do the close, and
you want to tell me what that question is?
Yeah. So Connor and I'll do the close, and then we can, if we have time, you can maybe hang around a couple minutes and take 1 or 2 others.
Sure.
Okay. So here's a question with only 3 upvotes, but it's a what should members do when board members repeatedly make things personal e.g. a personal attack and belittling members, or they make decisions not based on facts, but unverified false assumptions and things like that. What do you do when you have a board like that?
Vote in a new board. Look,
That's right.
this is your right. It's described in the subdivision condominium white report for your community. If people are disrespectful to you, one, that's kind of a poor reflection on them. You might take a minute and look at it from their point of view, which is to say that they're donating their time to the board and they trying to figure out how best to manage the association's funds. And sometimes, they're just people making sometimes bad decisions, but there's never room for disrespect. There's never room for you to be disrespectful to a board or the board to be disrespectful to you. And if they are, the next time there's an election, vote somebody else in who is going to be more respectful.
And that brings up a bigger question, is getting board apathy and people in community apathy. Sometimes boards do get a little bit aggressive or unfriendly, and they forget that they're representing a community, but the community also needs to make sure that they understand that they don't like that behavior. And
yeah, it's they get comfortable, right? Like,
yeah.
You know what? Nobody runs for the board, so we're stuck with this job. And so we can kind of treat people however we want, and that's just not the case. Anybody should be able to feel free to volunteer for the board, and the more people who volunteer for the board, I think the more respectful our boards are going to get.
Okay, and so here's 6 upvotes, which I think is pretty good. For Patrice, can the HOA recover attorney fees via reimbursement assessment from the offending party if everything is done properly and resolved before a claim or lawsuit is filed, or does the HOA just have to eat those costs?
So it really depends. So in the scenario of I had a situation where the association was sued under fair housing, and we did make a complaint against the owner who we had gone through the hearing process. So had to be careful about the facts here because obviously this is all handled under a litigation privilege. But what happened generally was we had a bigot situation. We had a person who was throwing rocks at the house of some people who were gay. And I didn't do it. And we scared them and said, hey, this can be a real issue. What this guy didn't realize was these other guys had video. And so when the Fair Housing Department arrived and they sued the association, of course, we cross-complained against the person, the bigot. And essentially, the bigot had to come out of pocket to defend the association and against the Department of Fair Housing. And it was a very quick case because the Department of Fair Housing had the video of the 2 gay guys. So what happened? Well, the association did end up coming out of pocket because that owner immediately filed bankruptcy. Okay, so even though we could have gotten or did get a judgment against them, it was invalid or irrelevant, right? So it's kind of one of those situations where, yeah, you can do it, you flap your arms really hard, maybe you'll fly a little bit. But that doesn't make the association whole and won't. It destroys the other person, which maybe is all fair in love and war, which is to say it financially wipes out the bigot, which is maybe, like I said, a good thing. We can judge that. But the answer is nobody's really made whole. These are just really bad situations, and the best thing you can do is move quickly to try and dissuade the action, and that's by bringing the people in for hearings and talking about it.
Okay, so this is the last one we're going to take from the Q&A, and then I'll do the closura, the end here. So from Teresa, and we got, or actually from Melissa, and it says our HOA holds its monthly meetings at the local fire station that sits on the border of the HOA property, approximately 1,600 acres without a community center or building to hold meetings indoors. The meetings are at the fire station permitted. Are meetings at fire stations permitted? So at that location, One of the HOA members claims disability and that the fire station is not ADA. Surprising to me that it would not be ADA. It seems like it would be, and because
Yeah, that's pretty hard to imagine. But back to the first question. The question was, where can we meet? Right. And the answer is anywhere that your bylaws say you can meet. So usually your bylaws say that you should have to meet in the county or within the project or within the state, right? And they can really say any of those things. You need to check. I have community associations that I represent in Palm Springs that meet every year in Beverly Hills, different county, different, might as well be a different state.
yeah.
And so, you just need to look at your bylaws. Again, you're not required to meet ADA. I mean, the fire department's required to meet ADA, but the association is not. And so, anywhere you meet, as long as a person has access to it, is fair game. And I got to believe a lot of those claims are going to go away as we get better with Zoom, remote meetings and that kind of thing. That may be a great way to help that person accommodate. But the first thing you want to do is meet with them, sit down and talk with them, and have a hearing and have a record that there was a hearing. Protect your community and meet the needs of the person by making sure that person is heard.
Mm-hmm. And public buildings like that, they have to meet ADA. I mean, that's what the law's intended for, right? So access and what have you. But anyway, Mark, I want to say thanks for your presentation. I love doing this one, and we need to have it. We need to have more conversations like this. There's always nuances, and it's wonderful to have you be so approachable and personal on these things. So thank you for that. And I will be going into my closing remarks here, and then we'll come on back and see if we have a couple more minutes to do one or two more questions. Okay.
Oh, okay.
That sound good? Okay.
Sure.
I want to thank you to all the ECHO members for coming today and supporting us. It's always a pleasure to have you here and to continue on your growth with your education about HOA management. So thank you so much for that. For those of you who are not ECHO members, please consider becoming a member and supporting our programs and projects that we have. You can become a member across the country. We just signed somebody up in North Carolina, and we have someone from Pennsylvania. So we have a lot of places all over the state and the nation at this point. So it's really easy to become an ECHO HOA member. Just go to www.echo-ca.org and click on the membership tab. It's all online now. We improved our system over the last few years, and so this can all be done safely online. For ECHO members, I want to say thank you in supporting us again. And would you please invite your friends and neighbors and board members, and especially any of your vendors or even the management firms that you work with, to become an ECHO supporter. It's simple. Just often, if you just ask them, they'll join, or at least they'll look into it. And that's all we can ask. If you would like to become more involved with ECHO, we have several opportunities for you. Please refer to the slide. If you see anything that looks particularly interesting, please let me know. I'm Dave Zapponi at echo-ca.org. We have a number of events that are coming up that are in person. We can always use people to help with those for an hour or two, or there's more in-depth programming that our responsibilities that we have, like social media and what have you. So there's some few things like that we can use some help. ECHO, just so you know, ECHO has 3.5 FTEs. It's Connor and myself, and then we have one person in, actually she's in Oregon. She handles our membership. And then we have one person that's half a person in San Diego and half FTE in San Diego. This year, ECHO is launching a new educational program focused on HOA board member preparedness. The core curriculum is 10 courses, and they're designed for high quality training, and they are available online, on demand, or there's 2 of them that we require it to be live online webinar. So please thinking about it, you can definitely become a member. You can definitely take these courses. You will get a certificate of board member preparedness. It's a certificate of that you've actually attended and participated in the program. And we do tests after each one, so you have to pass with a 70%. Not tough tests. These are tests just to indicate that you have been exposed to this particular training program.
Did you just say exposed?
Yeah. So it's really important for new members or people considering becoming members. We found this to be a really good tool to get people engaged in the community so that they can understand more about what it takes to be a board member. And we have these 10 courses. They're on the screen right now. You can see them. We have a good governance series on how to run and manage meetings, candidacies, voting. All of these things are part of the program. Excellent course. The HOA Legal Environment series, which Mark helps with as well. We have Ask the Attorney. So Davis Sterling, we go through, we do laws other than Davis Sterling. That one's coming up, I think, next week, and or at least soon. And then we have the judicial interpretation. So that's the legal side. We have board ethics, which is a two-part class, A and B. That one you actually do have to take live because we do case studies. And then we have HOA financial management and reserves, which is coming up later in the summer. And that'll go through all the financial reporting and requirements. And we'll also do some internal controls on how to manage fraud in that particular program. So that's a pretty good class, and we all should go through that. I'm a board member as well. That's why I'm saying we all need to do that. And HOA board member preparedness. I'm going to do a capstone course, which takes all of this into consideration, and we look at a more strategic look, sort of the drone level, get it up there and look down and see what you really want from your community over the long run. And so if you're interested in joining that, just give or being part of that, just contact Connor at echo-ca.org, and he can fill you in, or you can go online. It too is online. Our 2024 resource panels will continue on May 14th with the Sacramento Resource Panel, followed by the TCAR, which is the Echo Club at Rossmore in Walnut Creek, meeting on May 15th. Ending the week with our East Bay Resource Panel on May 16th. So that's in San Ramon. So if you would like to participate in one of those, we'd love to have you there. The Echo is planning 3 larger events this year. We have one on June 22nd at the Villages in San Jose. If you would like to go to that, I would encourage you to sign up early. We do have an early bird registration, which waives the fee. We've secured Senator Dave Cortese as our keynote speaker. He's on the California Senate Housing Committee, and he's going to be talking about housing in California, which has a direct bearing on HOA management. We'd like them to give us a little bit of a break on all the laws that they've been sending our way. And maybe if we have some changes, it's a good opportunity to be able to talk to him and his staff. So we ask you to come to that. CAL FIRE has tentatively agreed to participate and talk about ways to harden your communities. CAL FIRE runs the Fire Safe program, and they have another program called Subdivisions. And these are hardening of communities, making it better for your community to survive fires. And they also have some money, I understand. Hopefully they'll talk about grants that are available for communities. And once again, I want to thank our sponsors for making this community conversation possible. And thank you to Mark for developing and presenting the material today. I love it. I always do. Mark's a good friend of mine, and he does a really wonderful job. So thanks, Mark.
Dave, I want to jump in because I think that as I review the questions, the majority of the questions, I don't know if there's anybody left on, were, hey, you never really laid out what California law protects. And so I put it in the chat, but essentially race, color, creed, ancestry, national origin, religion, age, disability, mental or physical disability, sex, gender, including pregnancy, childbirth, breastfeeding, or related medical conditions, sexual orientation, gender identity, gender expression, medical condition, genetic information, marital status, or military or veteran status. So these are all the things that the Department of Fair Housing will swoop in to protect people from discrimination on.
Okay, that sounds great. I know last legislative session, or the first part of the legislative session, there was a bill that was run on the caste system, and that one didn't pass, which was pretty interesting last year.
Yep.
In any case, thank you so much for coming today.